of the questioning.
Of course.
So that conduct, you don't need to be friends for that conduct to and be subjected to investigation. We are not discussing his conduct. We are discussing your relationship with him. Why can't you comment on that without necessarily saying anything about his conduct, which you suggest IDEC is investigating?
Commissioner, I've already done that. I don't know whether you want me to say, I told you he was not my friend. He's not my friend. But there's an investigation that is going on. What is it that you say I cannot comment on? Unless now, if you want me to explain what is it exactly that IDEC is investigating him for?
No, that's not my question, because you want that to be my question. I'm staying away from that question. I do not accept, just for the record, that he's under investigation, because you haven't even proven that he's under investigation. Your say-so is not enough. It's not your get-out-of-jail card to refuse to answer a question simply because you suggest or you suggest that there is an investigation, and there is not a morsel of proof before us that there is such an investigation. It is no answer, but that's not what I'm asking you about your relationship with men, and that you describe the relationship. Is it a long-term relationship initiated on that particular date when you went to complain about the hospital, the SAPS hospital? Does it sustain? Has it broken down? Was it very close? Was it a business relationship? I'm giving you. So far, I haven't even gotten anywhere close to what and I'm demonstrating you can answer that question without reference to what you claim IDEC is investigating him for.
Okay, then which question do you want me to answer?
Please describe in your own words the relationship you have with General Sibia you had, and if it assists you, and the one you currently maintain.
The relationship that I have, like a friendship relationship.
Okay. It was not like something, it has to be like another. What was it like?
Now you're pushing me to say something that I do not know what I will say, because he was not a friend, yes, and go further. The only way is to go now into the contents of the investigation, which I do not want to tap in that territory.
Okay, let's...
Was he an acquaintance?
He's someone that I knew.
Thank you, Chair. Perhaps then let's continue. It might become clearer in time for the commissioners, the nature of relationship with the regulator 10.6 at 2.2.3, that's where I'm reading. The 10.6 required you, in respect of General Sibia, to explain the nature, extent, and frequency of your communication.
Communications, it was maybe once when I went to his office.
Okay. And by communications, direct or otherwise? Communicated with him directly, and have you communicated indirectly? If we talk about indirectly, please explain the method you conducted then.
Directly, yes, through, I sent him an email.
Yes.
That was the first time. And then I've called him directly. So I only spoke with him, I think, I'll say 3 or 4 months. I'm just saying on top of my head, I cannot remember well. Maybe I'll say 3 or 4 months after I first met him. And then the communication then was through a third party, same Sergeant Nkosi.
And how frequent was that communication?
Frequent, plus minus 3 or 4 times.
And what was the communication about?
let's leave it there because that is the publication.
Is the engagement party you attended of his daughter or son, are you seriously suggesting it's part of ICE investigation?
Yes, it is.
What manner? As to who engaged who and why, or why?
I think I'll have to discuss with my legal counsel because I'm in possession of my tool. It's a way for you to understand that it's for you to see the statement, but it is.
I think then it would help for the commission and the basis on which you seek to assert this right? Because the attitude you are adopting is you cannot ask me about General Sibia because IDEC is investigating something somewhere.
Commissioner, fairly speaking, I have to go to court and account. I cannot now ventilate anything that is to do with him, especially something that is already being under investigation. I do not know even whether he will be charged or not. So chances are he might not, I don't know that. But currently myself, I'm charged and I have to go to court and account for these things. So I don't think it's fair for me now to speak about something which I'm not sure at the end of the day whether I'll have to account for that or not.
You see, the challenge I have, Mr. Matlala, is I think you conflate yourself with General Sibia. You are not General Sibia. You are facing charges for your conduct and I think to even stray into that discussion. We're talking about something separate, which is your relationship with yet a third party who's not charged with you. So I don't understand, in the current criminal case that you are facing, how you'll be called to account for your relationships with, including General Sibia. How does that come into play?
It actually does.
How?
I don't know. I'm not an investigator.
Okay, then I'll tell you that it doesn't. You cannot even, I won't even say prove, it's too high a threshold. You cannot even persuade the commissioners that it is relevant for purposes of the current criminal case you are facing. You are not able to.
I do not accept that.
Okay, then if you don't accept that, then demonstrate to these commissioners that relationship to the charges you currently are facing.
I think I've just said it. The only way for me to demonstrate that is for me to now to get right inside the cracks of the matter, which is something that I cannot do.
Then I'll put this proposition to you, that you don't want to talk about the nature, extent, frequency of your communication, General Sibia, because if you do, you're at risk of incriminating yourself in some offense, because by their very nature, they would be breaching the law. That's my proposition. What's your response?
I cannot argue with you on that.
Okay.
That's how.
They said legends were only myths, that protectors like this only existed in stories. But when danger calls, when all hope seems lost, a hero will rise. Every dog has a hero inside them. Bobtail for strong South African.
Has said to you, because ultimately the Commission must be satisfied that the privilege against self-incrimination, and for us to do that, we need to know what it is. Looking to, not in general terms, general broad terms, but specifically. Having said that, when I say I can put this to you as an example. You have had interactions with General Sibia. We know you sent an email, you went to the office, and you do say it had to do with the lease. I think it's competent to ask you, have you had a Medicare contract still at general terms? And if you're asked what exactly, you can say to resolve the lease. You testified in the ad hoc committee, for example. You said you interacted with him of, I think, Mr. Bushokha and Mr. Khale. There's no, that has nothing to do with your Medicare contract. Then you are not being frank with us if you don't say, well, other things that have nothing to do with it I've dealt with him. Then you're not being frank with us. The chairperson said to you, asked you, have you socialized with him? And it had to be put, you know, it had to be dragged to you, in my opinion, for you to say, yeah, demonstrate or would explain and say about your interactions with General Sibia, and there is no basis or valid basis for you not to speak to those when you're asked to explain your interaction with General Sibia.
I think also what Commissioner Balo is referring to, I think at sight of the ad hoc committee transcript. If I'm not mistaken, I think it's in that transcript where you say, in fact, you contradict what General Sibia said before us here. You say you attended the engagement function, and that you did not go there just to pick up your wife, which is what General Sibia told us. You say you attended that, and as I understand it, you attended as an invitee, and you were there. You had much longer than just going there to pick up your wife. So raising that in support of what Commissioner Balo is saying, which is a lot you can talk about. And I don't know it's incriminating for you to tell us that you went to the engagement party and also to contradict General Sibia on what he about your attendance there.
Thank you, Chairperson. Chairperson, it's not only the Medicare tender. Like I said before, it's also the content holdings which are also putting me at the risk of self-incrimination. So, know how the approach of, I cannot tell now, as I sit here, what is the approach of the investigation. I do not know. I was not yet charged or even being under investigation. So now it's a different thing now. I'm charged, I'm also under investigation.
You have only two bases on which you assert that privilege. You're either an accused or you're a suspect. No encompassing protection or umbrella that you say, well, I know it's being investigated and I don't know which way it will go. That's not what that protection that is given to you is all about. That protection applies if you show that I'm an accused on this issue, this very issue. And so I shouldn't be required to speak to it because I'll self-incriminate. That is the easier part. The other is I'm a suspect. But even there, you have to provide details because, as Ms. Silla says, you know, you don't just say I'm a suspect and that's the end of it. We are entitled to engage you to establish that indeed you are a suspect. If you're a suspect, of course, we have to be careful what we ask you if you are asserting that privilege and engage with you. That thing is in the recordings is not sufficient to invoke that protect recordings, and those recordings are being challenged. They are going to use those recordings. Therefore, I should not be required to answer those. I think you can accept that if the privilege is properly, if you rely on it, the commissioners will give it properly because we wouldn't want to impinge on your fair trial rights. You can accept that. The burden is on you to show us that in answer to a particular question will tread into your fair trial rights and respect that. So far, you're speaking in you're dealing with matters in very broad and general terms, and that doesn't avail you. It's not available. But more importantly, you are either a suspect, and you have to show why you say you're a suspect in a particular matter, or you're an accused. Those are the only two circumstances. I don't know if you want to comment.
Yes, I wish to commission. I said I will make sure that I get the transcript from the pre-trial to prove that I'm actually a suspect in those recordings, and I will that in those recordings I did not know to which extent they're going to investigate. So I do not want to be careless by saying something that will incriminate me, but that is a fact that I am under investigation for those recordings, and then I will prove it by grips so that you will know that actually I am a suspect.
Do you accept that we have to have those transcripts presented to us? They must be engaged upon with you. They must be before us. You must look at them. We must engage in order for us to agree with you on any item. It's not everything that's in the recording. I take it that you say is untouchable. But even if that's what you're saying, that everything in that recording is untouchable, you do accept, at least I think, to accept that those recordings would have to be before us, and then to engage with you when, that part, if I deal with it, I'm self-incriminating. You accept that?
The recordings, I do not want to deal with them because they are under investigation. What I wanted to do is bring the transcript to show that this was being investigated.
Transcript of the recordings?
I'm sorry, I meant to say the contents of the recordings, yes.
That's what you mean. When you say transcript, you mean the contents?
I said I will bring the transcripts to prove that what is in the recordings, I'm actually being investigated for that. So for me to prove that is to bring...
Yeah, I'm trying to clarify the transcript of what?
Of the recordings. No, I'm sorry. I'm sorry. The transcript of the pre-trial where the state advocate mentioned that I am under investigations in regards to those recordings.
Okay. All right. But you've heard me, what I said earlier.
Yes, I did.
We would hear as per question or topic. We need to see that indeed, if you are required to answer a question, a specific question relating to that topic, then it does validly raise the self-incrimination defense.
I take that, yes.
Thank you.
Thank you, Chair. Perhaps if we could see if we can quickly work through this list. Sub 2.2.4, which required you to comment on the nature, extent, and frequency of physical meetings and or gatherings with General Sibiya, when, where, and how these meetings were organized. Provide details of the persons in attendance and as well as each such meeting. So if we look at 2.2.4, can you tell the commissioners how frequently you met with General Sibiya and under what circumstances?
I will say maybe 3 or 4 times.
Can you deal with each incident as to the purpose of that meeting and how it came about?
The first time I've already mentioned it. And the second time is when I was going to get a feedback feedback of what I was complaining about.
And how did you get that feedback? Where and
I went to his office also.
once again? And this was to get feedback on?
The public works lease agreement.
Okay. And who arranged that meeting?
Sergeant, I think it's Sergeant.
Heard about the new signing?
What's that?
Everyone's talking.
I heard the election. Really?
Hard. Covers every position.
Gonna change the way.
He had my telephone number.
Say that?
He had my phone number.
You still don't tell me how he communicated with you.
I'm saying he called me.
Okay. Now,
And when he called you, did he call to say General Sibia wants to meet with you to give you feedback? Because it's Nkosi that calls you.
Yes.
Is that how it happened? Thank you. You said yes, Mr. Matlala.
Yes. Yes.
I too had missed the answer, sorry. So that is the second time. Now, the next time?
I think I will confuse the timelines because it's a long time ago, but
Okay.
there was an occasion where he asked me about the Jerry Boshoga, so I do not know whether it was the third or I don't
Okay.
know that.
Now, can you tell us more about that engagement? How it came about and who initiated it?
He initiated it, yes.
Directly with you or through Sergeant Gossi again?
Like I said before, he never had even once.
Through who did he do this?
With Sergeant Ngosi.
And what about Jerry Boshoga? Did he want to engage you on?
As after the raid from my house, because the police came to my house and then they said that they were looking for a kidnapped victim.
Okay.
And then later I just don't know, I can't remember when, but at some point I went to him and then that's when he asked me that, what do I know about that?
Oh, you went to him?
Yes,
Is it back at the office now?
yes.
Who helped you to set up that meeting?
I said it was Sergeant Ngosi.
No, the Sergeant Gossi, remember we stopped counting and I do accept that it's a long time, so you won't exactly know whether it's the second or third. Organized for you to get the feedback on the lease agreement. That much you said.
Yes.
So now this is yet another meeting and you didn't want to comment to whether it's the third or the fourth. This is regarding Mr. Boshoga. You said he initiated it. You said General Sibia initiated it and you said he did so through Sergeant Gossi.
Yes, I said.
And you said you went to him
Yes,
at his offices.
yes,
And so he requested to meet you.
yes.
What about? Did he explain?
Are we still on?
On Mr. Boshoga, yes.
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 Yes, it was about that. He asked me what I know about that.
If I understand your communication channel, he would ask Sergeant Gossi what you know about that. Sergeant Gossi would ask you in turn what you know, that General Sibia wants to know what you know about that. Your response would be, no, I don't know much, so I know whatever, and then is that how the communication,
No.
oh, please enlighten me.
He asked him to arrange a meeting, then I went to him,
Okay.
and then that's when he told me.
So he initiated engagement with you.
Yes.
Do you know in what capacity he did so? Was he investigating this kidnapping or was he as an interested person, as a relative? Did you have a sense of why he reached out to you on this matter?
Yeah, I think he was said to me, but I don't know what to make out of that. But he said if he can crack that case, it will help him a lot. So I don't think it was because of he was a relative or something.
Okay. So he initiated this contact for purposes of investigation?
I think so, yes.
Now, if it's in, that would be in his official capacity, I take it, as a police officer, I think a senior of the service.
Yes,
It
he
would be
was.
official.
I don't know how we will justify it to be official, but he just called me as a police officer, so I don't know.
And that's precisely what I'm trying to determine. It's a police officer.
Yes.
You have been questioned about the kid, Mr. Bushoka. I take it was not by him the first time when you say they came to your residence.
Yes, yeah.
So now we know that he subsequently becomes involved in it by requesting a meeting with you. Correct?
Yes, that's correct.
Hence my question, did you understand him to be investigating that disappearance of Mr. Bushoka? What was your understanding? What process were you engaging in, seeing as so far you had just met him twice about the lease agreement?
But as a senior police official, maybe he will refer the investigation to someone else. I don't know how it works, but I know that he called me and then he asked me questions in relation with Mr. Bushoka.
So you don't know whether he was doing that as an investigator into the kidnapping?
I cannot tell that. I don't know.
Okay. And were you able to respond to his questions to satisfy his curiosity?
I think so, yes.
Okay. Now, you said that's your third meeting, but you did say that it was some time ago, so now you're no longer so sure. I will just talk about the next contact you had with him. When was the next, and who initiated it, and where, and what about?
Okay, let me say this, because all of his requests to meet him was through Sergeant Nkosi. So from now on, whenever he called me, it's through Sergeant Nkosi.
Okay.
Yes.
So then before you get to my question, if he was an investigator in this Mr. Bushoka's disappearance, shouldn't he have contacted you? What investigators do? Couldn't you have obtained your number from Mr. Nkosi and say, I, as a general in the police service, I need to talk with Mr. Matlala for whatever reason, because I'm investigating a kidnapping? Why couldn't he contact you directly?
That I cannot answer. I don't know that.
So you did make the point that all future and past contact with him was initiated through Mr. Nkosi. As a matter of interest, did you ever inquire why or who made Mr. Nkosi the intermediary between the two of you?
I think it's Mr. Nkosi himself who started this thing.
How does he do that?
Because he's the one who gave me his email address.
Yes, the first time I can understand, but why couldn't you then have your direct contact with General CB after that, after the initial contact? Why did you always need to work through Sergeant Nkosi?
I do not know that, but that's what was happening. I don't know that.
It never crossed your mind that by now you are on your fourth contact, the one we're going to discuss next, that perhaps your relationship has developed to a point where you can contact each other directly?
Commissioner, when that thing was, I wouldn't know by then, but now I will understand why that was happening. But unfortunately, what was happening is something that I cannot speak about. I think I requested that some part of my evidence I will request, because I'm under investigation. I'm really under investigation. I'm not making this up. So I asked that maybe if it's possible that I can, some of my testimony can be in private, because I cannot risk incriminating myself. That I cannot do.
Does Mr. Bushoka's kidnapping have anything to do with Medicare 24, which we know is the case you are currently facing in
Medicare
court?
24?
Yeah. You have always invoked Medicare 24, and I'm interested to find out now whether Medicare 24 is relevant to the issue of the kidnapping of
No, it's
Mr.
not.
Bushosha?
No, it's not.
Okay, so Medicare 24 is out of the way. So what is the basis on which you cannot speak? You say you're under investigation by who and for what?
I'm saying, we're speaking about General Sibia now. I think your question is in relation to General Sibia. I'm
Yes.
saying I'm being investigated, and then I'm also charged in relation with the Medicare tender and also the recordings that I mentioned.
You hit your mic,
Sorry.
thank you.
The recordings that I mentioned earlier, that also his name is been mentioned there. So I'm saying this because I know for sure that there is an investigation going on in relation with those recordings, and also I've been questioned about him by IDEC.
IDEC.
Yes.
Okay, perhaps if we look at it this way, what do you, to your understanding, what is General Sibia being investigated for? And by who?
Now, for me to do that, obviously I need to disclose the nature of the investigation and my case.
No, that's not. What is he being investigated for?
Yes,
Which offense?
Yes, that offense, for me to mention that offense, I'm saying now I have to speak about what I'm trying to avoid.
No, that's very cryptic.
Can I
Yes.
try? Mr. Matlala, you reference to IDEC investigating General Sibia. Is it about, does it relate to Mr. Bushosha? That
No.
you can answer.
No, I said it does not relate to that.
It doesn't relate to
Yes.
him. Does it relate to the Medicare contract?
Yes, it does.
Okay, thank you.
Thank you, Commissioner. That's the point I made. I said we'll stay off Medicare 24, but you can talk about the kidnapping of Mr. Bushosha that General Sibia investigated, and in the course of investigation, he engaged you. What's that got to do with Medicare 24? Nothing, right?
No, we're not speaking about, it's two things here. So Medicare 24 is a separate thing. So when you called me about Mr. Bushosha, it has nothing to do with Medicare 24. It's something different.
So which means then we can talk about what your
One Plan. Health, pets, gap insurance. Visit oneplan.co.za to get your quotes today.
Okay. I'm looking at the time, perhaps a comfort break, I don't know. I appreciate we started late, so I don't think it's appropriate to stop at this juncture, otherwise we'll run into trouble time-wise.
Let's take, what? Let's adjourn and come back at 4:10.
1, 2. All right, we said we would resume. It is 10 past. Please make sure your phones are off. Thank you.
Yes,
Thank you,
Mr.
Chair. Oh. Chair, before we get lost in the questioning of Mr. Matlala, I just need to clarify something. The Chair ruled that document that Mr. Matlala refers to being, as was described, regarding, I think, Mr. Hangumela and Mr. Sule Karim, or one of them, which is part of the documents currently being collated by his legal representatives, which we have established is the SI document and is available. The Chair ruled that it be made available to evidence leaders. I understood that there were some challenges. I was hoping to have a quick chat with Ms. Missy before I address you to find out if there are challenges in regard to providing the evidence leaders with that document.
Chairperson, I did indicate I do have the document. It's in. Had you requested it before I'd run out, Ms. Mhlapa, I would have given it to you. But now that is it okay for us to give it to you once stopped, or do you need it right now?
I would prefer, before we rise today, that we have copies in preparation for tomorrow.
Okay.
Okay, thank you.
Thank you.
Then continuing, still looking at the instances you met with General Sibia. Do you know what investigation did Mr. Bushoka's kidnapping? And my second question is whether he reported back to you about that.
He never reported back to me.
Never reported back. Did you have any dealings with General Sibia after that engagement regarding Mr. Bushoka's kidnapping? If so, can you just quickly articulate the dealings?
Meaning?
Any engagements with him, further discussions?
The book about this, the one that said I cannot go into that, the details of that engagement.
Now, you cannot, okay. You are setting this time?
It's both, because I've been questioned about him, and there's a statement that is made, the 204 statement, and also is because the investigation that is currently ongoing.
Okay. Then let's take it one at a time. The Section 204 statement made by who?
By myself.
Okay. In which matter? Which investigation?
Medicare matter.
Medicare matter.
Yes.
I take it the Section 204 statement is one that would effectively render you a state witness.
No, I'm not in this.
Okay, so what Section 204 statement are you talking about? Unless I've got my CPA all mixed up.
I do not know how, sorry?
Yes, I think Ms. Missy, Advocate Missy might help.
Chairperson, if I may at this point. Chairman, you'd have noted earlier on we made reference to the fact that some of the claims to privileges that he wants are in relation to the questions that were asked to him during the interview for this and may be found in the 4 affidavit, which is a privileged document, and which is why we were of the view that the attorney on record would be another individual who is also an officer of the court who can confirm that he really is a suspect with regards to these interactions with said individuals, and therefore would be in a position to claim privilege. And so, which is the reason why Mr. Matlala keeps making the submission that I cannot speak to this here because I'm being investigated. I've addressed it in Section 204, and you would note that when you are being investigated as a suspect, as far as I understand, it's not specified to you that your charge is A, B, C, D, E, F, G. And therefore, it makes it even harder for him to pinpoint exactly why said information was required for me to give to the individual in 204. And therefore, I need to claim privilege over this particular point. Chairperson.
Oh, Ms. Zildo will respond, but may I say this so long? My understanding of how Section 204 works is that somebody who may be charged of an offense or who has even already been charged of an offense may then be engaged by the prosecutor to used as a state witness. And then in terms of Section 204, that person may then be discharged in the sense that they will no longer be charged with that offense. But if they answer all questions truthfully and satisfactorily, and they are even called a Section 204 witness. So just before your, or what you call interjection, Sillo wanted to understand if Mr. By his repeated reference, his Section 204 statement, he is suggesting that he was or was to be a Section 204 witness. Yes, Mr. Law.
Indeed, Chair, that's what I'm trying to understand, because if it's in respect of Medicare 24, what we know right now is Mr. Matlala is an accused person. If he has signed a 204 affidavit, which, as the chair points out, he could be discharged from the charges that he's currently facing, and I need to test whether or not he's become a state witness in a matter, which, as I understand it, is the matter in which he deposed to a Section 204 affidavit.
Or if those, how then does a Section 204 statement feature?
Chairperson, my apologies. So the point, so it didn't become a Section 204, to my understanding. And so with that being said, that information then made him, that with regards to point A and C, D, I'm a suspect and I'm being investigated. And that's how he then came, we have come to the conclusion that he may be in a position to claim his right to privilege.
How do we, without sight of the 204, how do we as commissioners determine whether the reliance on Section 204 is properly raised? And that properly as in is, it's validly raised and it should be upheld.
Chairperson, in that instance, we tried to aid the situation or the dilemma that we also had come to, as per your question. And the only solution that we could come to is that the attorney, being an officer of the court, would be in a position to confirm that indeed, to the extent of ABCD, having read this affidavit, can confirm. And up in that point, then it would the commission in a better position to say, well, Mr. Matlala and through his legal team are actually CT. But as it's like now, it would be impossible for him to engage you with regards to those points. And again, as we had apologized with regards to being able to deliver the replying affidavit timeously for the commission to have sight of it, because that's the main reason why we needed instructing attorney to both have the docket and the Section 204 and give the commission an insight into it.
If I may, I think there is a third option that advocate Ms. is not alive to, which is providing this commission with that Section 204 affidavit, even on a confidential basis, the commissioners and the evidence leaders to consider the contents thereof, to appreciate the rights that Mr. at every turn as a result of that Section 204 affidavit having been deposed.
If I may just add to that, because I was thinking along those lines, that if his attorney, and underline this, which you said is an officer of the must take his word for it, why does that not apply to the evidence leaders who are also officers of the court and officers of the commission and the commissioners as well, as a quasi-judicial body made up of lawyers? Why does that not apply to them? That's aside from the question of, surely you couldn't be saying that the word of the attorney must be taken of Mr. Matlala, and if the attorney says, that's what that affidavit says, we must be blind to the document, and without it coming to Matlala's mouth, we must accept that what the attorney says, we have to make a decision on that basis. On what authority, on something so important and with far-reaching consequences, on what authority would you say we proceed in that way? But it's not just a matter of preference. You obviously prefer that. So put preference aside. It doesn't work on preference. It works on authority for denying the commission the access to that Section 204 affidavit, especially where Mr. repeatedly invoked it. He's referred to it. It doesn't come out of a vacuum. We are having this conversation because the witness in the box saying it's in the affidavit. Why are we not entitled to look at it? And the why, the answer to the why must be on authority. You have to look at Section 204 affidavit.
Chairperson, if I might be given a moment to just confirm with my learned friends. Chairperson, if I may, Commissioner. In terms of Section 105.10, when you're no longer a witness,
Of the Criminal Procedure Act?
Yes, of the Criminal Procedure Act, you are then given a right of privilege over any information that you would have deposed to in the initial affidavit. And the moment you expose that affidavit, any and all issues that are addressed in that affidavit are now in the fray. And you waive your right to not be, you waive your rights that's what we do is that if there's even an issue that he has addressed in that affidavit that he's given privilege over, even if you hadn't considered it, if we expose it to and not through his attorney who has legal privilege, it then implies that you would have seen all the information that he's given protection or you wouldn't ordinarily be entitled to, which is protected not to disclose to anybody else, as we have now established that he's not a state witness, Chairperson.
Thank you, Commissioner. Perhaps we might benefit from taking a step back, and I do so by posing a question to Mr. Matlala. Mr. Matlala, you concluded what we call a Section 105 capital A plea and sentence agreement with IDEC, didn't you, in this Medicare matter?
Yes, that's correct.
And that agreement was presented to the court as it ought to and was considered by the court, and the sentence was rejected by court, and the court counter-offered with a higher...
That's correct.
Which, in terms of the law, you have a right to consider, accept or reject, and you elected to reject it on 10th of July 2026 at your appearance in court.
Yes, that's correct.
And you accept that once you rejected it, the entire Section 105A plea and sentence agreement fell by the wayside, became null and void.
Yes, that's true.
Now, the affidavit that we are discussing now, you deposed to in the process of negotiating that Section 105 capital A plea and sentence agreement, am I right?
Yes, that's correct.
Now, both of them have since become null and void. Do you accept that?
Yes, I accept that.
Okay, that's perhaps now to address myself to Advocate Missy. There's Section 10 of 105 capital A simply says that the trial starts quote-unquote de novo, and the contents of those documents are not applicable as against the accused person in that particular trial. That's what the subsection provides. Now, Advocate Missy seems to extend that to suggest that both documents cannot be considered, even if it's not in the guilt or otherwise or witness before us, because they've become null and void for purposes of that criminal trial. There are some privilege to them. I'm still not clear as what privilege exactly Advocate Missy is extending.
If I may, Chairperson, I have here before me the actual provision. And at subsection 10, from letter number B, sub B. No, my apologies, sub A. Unless the accused could the recordings of all certain admissions made by him or her in the agreement or during any proceedings relating thereto, any admission or record shall stand as proof of the admission if it does not fall de novo. So our understanding interpretation is that the fact that he does not consent giving his right with regard to the information that he had given willingly in lieu of the fact that he would stand as a state witness then implies that he can't disclose any such information that he had given willingly in lieu of the fact that he would be a state witness. The problem then becomes where this document is a privileged document. And my understanding is our argument is submissions, right? That if we then say outside of his legal representatives who have privilege of this information, we hand it over to the commission, it then implies that not only are you going to be able to look at those particulates that you're asking questions about, any and all information that is disclosed in there that you possibly have not even considered asking questions in a position where you have sight of it and you very well might say, well, but we think and we consider this not to be something that's privileged. And so I do not understand it possible that the commission would be able to close its eyes to any other point that's made, not only vermins that he made relates to the questions that you are asking. Because the more, and our understanding is that the more you very well might look at the affidavit, he loses his privilege not to have that information that is given to those proceedings exposed.
If I may, and perhaps it's time to turn to Section 105A. The rights that are protected at section, particularly sub 10, which Advocate Missy refers to, are intended to protect the accused against any prejudice as a result of the agreement concluded or the plea and sentence agreement in that particular trial. That's all. Advocate Missy suggests that the privilege extends to the world at large, whereas the privilege in terms of the section itself protects the accused person again in that particular trial, where he deposed to both the plea and sentence and in the Section 204 statement affidavit. So, Commissioners, I suggest there is no legal basis to provide both the sentence and plea agreement, which has since become null and void because Mr. Matlala rejected it of July, and it is literally pro-non-scriptural. It cannot be used in that court. Similar Section 204, David, that he deposed to. Both documents can never be used against him in the trial that is currently guaranteed. Capital A guarantees him that. So, if they are going to argue for non-disclosure, for the non-disclosure, not reliance on Section 105, capital A. This is not a court sitting contract criminal case. Thank you, Commissioner.
Ms. Missy, it's to make the obvious point. Matlala is not a criminal court before us. He's not an accused before us. That's the one point that and it's my point too. But two, it seems obvious to that Mr. Matlala have his cake and he can't invoke the Section 204 affidavit when he's required to answer questions. He can't say affidavit, and so I don't want to deal with it. And then at the same time, say you can't look at the Section 204. Then if that were to hold, and I've said to you on what authority would that ever hold, if that were to hold, it would mean that, in fact, he just needs to say that if I answer that question, or if I speak to that, whatever you're asking an answer, I'm self-incriminating. Your proposition or submission is correct. It would mean that's the end of that inquiry. It would mean that, and I want to say the correct position has to be that what he asserts when he invokes privilege, it requires that we must assess and evaluate whether that defense invoked. And the only way we can determine that is by looking at what he's refusing to answer. I'm still to hear you say that we are wrong in that position, that in fact sufficient. And if you are correct in that proposition, then we could never, ever, ever make any inroad with any witness. This can come and sit here and say, you know what, there's a recording, and in that recording I say things that are being investigated. That's the end of the matter. Similar 204, all he needs to say is there is a 204 affidavit. If I speak to it in any way, then I'm myself, and that would be the inquiry. We would never have a witness that answers questions. You may, if you have an answer, you may respond to me and to Ms. Silo.
Chairperson, it's not an answer, but my question then would be, are we to stick to a provision that refers to during or any proceeding relating thereto, that in these proceedings in the commission, we are excluding any proceedings relating thereto?
What is the relating thereto? What is the thereto that is referred to?
Precise.
These are not proceedings about the agreement. We're not having a trial that relates to anything that affidavit may be. We are not having a hearing about that agreement if the thereto is the agreement. We are not doing that. We are engaging, and I want you to remember how we get to this point of discussing the Section 204, is because Mr. Matlala repeatedly makes reference to the Section 204. He says, I'm not answering that. It is, and all of that is being investigated under investigation. That's how we get there. And for me, the fundamental question is a witness entitled to say that which your army is in a document, but you can't see that document, and that's a complete answer? It cannot be.
Commissioner, we're not saying it's just in any document. We're saying that it's in a document that is privileged, and in terms of which that agreement, the moment you don't become a state, and nobody has to have sight of it, because it then goes to the fact that he willingly brought himself and has made admissions, all admissions to which, as the commission, because you are investigating some of these occurrences, these events, and perhaps even the evidence that he makes reference to, it then implies that any witness that comes forward and says to the state, I am willing to be a state witness, let's negotiate. If that negotiation falls through, at that point will not reflect the fact that your admissions and the privileged document that you had entered into an agreement about is no longer.
Or not this section or statement or the content of it should be divulged. Could usually have responded to the question directly. If Mr. Matlala said, your question relates to A, B, C, D point, which is about one of the which I have been charged, therefore I risk incriminating myself, that we would understand. There is no him to refer to Section 204 statement as some umbrella cover for his protection. As I said earlier, there is authority from the Constitutional Court that says you must clearly identify the crime to which you are referring in asserting your privilege. And then that should take you to, in the face of that, the question put to is a question that you should or you should not answer based on whether the privilege under those circumstances can be asserted. You don't have to refer to Section 204 or the statement that you made under Section 204 and to then use that overarching protection. Once it's in the statement, therefore, I cannot answer questions relating to it. It should not. I see your junior next shaking her head. Maybe they're going to give you some brilliant point on why I'm talking nonsense. So we do not have to go there. We are not asking for the contents of the Section 204 statement is, because Mr. Matlala is asserting the privilege, Mr. Matlala should say, this is how your question impeaches on my privilege. That has anything to do with reference to the Section 204 statement. It does not have to. What I said right at the beginning, which is that without this umbrella cover all, that we should not have been in this in whatsoever. So much that I will perhaps, I'll let you respond, depending on, after the advice from your junior, I will then ask Ms. Silo to repeat and help me when I say, we do not have to just broadly and in general refer to a second, then say every and anything that relates to the questions you are asking me is contest. The test is there a crime? What is that crime? How do you relate to that crime? And are you therefore entitled to assert the privilege? This somehow been touched on in my Section 204 state. That's not the test. That's simply not the test.
Chairperson, if I might just get a moment to just confer, because I can hear as well that my junior does have a few points that she perhaps wants to relate to me. Thank you.
Agenda, you'll then indicate when we should come back. No, please feel comfortable. Don't rush yourself, because make sure that you will converse being said to you. But of course, we had indicated that we're taking the adjournment at 5. Let's adjourn rather than just sitting and watching. You'll indicate when you are ready.
Thank you, Chair. Yes.
Come here.
We're the people who move where the dust settles and answer without being caught. We read the land.
ARDA is a proud global supplier of sustainable, infinitely recyclable brand owners around the world.
This is not another forum, but all stand. Okay, let's resume. Please switch off your phones. Thank you.
Yes, Missy.
Thank you, Chairperson. We've deliberated about it, and I believe we had Edom with the last submission that you relates to him, have to specify what it is, what the charge is in particular, and therefore we should allow Ms. Selot to proceed and ask him the question and allow us it as per.
Yes, yes, and I want to, even if overnight now, but I'm sure you can assist even as we are seeing here. I want to have a look at paragraph 109 of, I think it was of the two judges referred to Ms. Hassim. Yeah, let me.
Yes, Chair,
Yes.
it's the Secretary Judicial Commission and Zuma,
Yes.
and it's a judgment of Justice Jafta, which was. It's just
Yes.
there are a few judges in that case. It's the one that
Yes, yes.
decided on 28 January 2021.
Yes.
And the operative paragraph for our proceedings is paragraph 10 on page.
The neutral citation is square bracket 2021 close square bracket ZACC. That's the neutral citation. Please look at paragraph 109 and you'll get the point I was making. And I hope your junior will now understand and shake her head very much.
Thank you, Chairperson.
Thank you, Chair. While on that point, perhaps it is necessary that we play a clip. This is an interview of Mr. Khanya, the spokesperson of PA. And in the course of that interview, he commented about the legal status of the debating. With your leave, Chair, Mr. Matlala, if you could listen carefully to Mr. Khanyaho's comments there.
Agreement is null and void, and we have to accept what the court has indicated. Obviously, it was not within our control as we had agreed, and when there was a change of sentence, and they had the right, obviously, in terms of the law, either agree or not agree, they did not do.
This essentially means, Mr. Khanyaho, that you have to go back to the drawing board. A was in that plea agreement, including what we understood from the court was an affidavit of the names of the senior officers who are alleged to have also been involved in this wrongful tender. That anymore, you go back to the drawing board. He then also has to join the other accused now who have been appearing in this matter. Clarification there.
Thank you very much. Definitely, because now the plea has been deemed to be null and void, nothing that was in the plea can be used. Therefore, we've got to conduct our own investigations from my side. And then, obviously, the matter will come back here on the 11th of September. And what will then happen is we'll then ask for the court to then bring him as accused number one in the other case so that he can now be tried. Because by not accepting is basically saying, I will run to go trial, therefore. That's what is
Thank you, Chair. Mr. Matlala, I hope you heard that. That for the spokesperson of the NPA, expressing the legal position as a consequence of your rejecting the sentence proposed by the court in the plea and agreement. And the point he makes, which is what we've been trying to persuade you of, is both that plea and sentence agreement as well, if it you deposed to in the process of negotiation of that agreement, which you refer to as the Section 204, affidavit have become null and void. So they will not be used in that trial. They cannot prejudice you in that trial. And as the Chair, I think, pointed out, or Commissioner, we are not part, this commission is not part of that trial. On that basis, Chair, I would seek to advocate in particular to Regulation 10, sub 6, which provides that for the purposes of conducting an investigation, the chairperson may direct any person to submit an affidavit or affirm declaration or appear before the commission to evidence to produce any document in his or her possession or under his or her control which has a bearing on the matter being investigated, and such person be examined by the chairperson or an evidence leader. That's Regulation 10 sub 6. I'll take it further, and the rules which at Rule 10 call for documents. At 10.3, the rule provides that should a person claim that a document referred to in the summons, which is required, is subject to legal professional privilege, they must, 1, identify the document in respect of which privilege is claimed, and 2, explain the basis for the claim of privilege in relation to each document. The remainder of that rule then deals with the questions of confidentiality and, of course, confirm the chairperson's discretion to determine that certain portions of such document or the document in its entirety is subject to a claim of confidentiality, which claim will be upheld by the chairperson. That's at the chairperson's discretion. Based, therefore, Chair, on regulation, we would request that the Commissioner's rule, the Chair rule, that Mr. Matlala and by extension, of course, his legal team, make available to the evidence leaders and commission, purely because Mr. Matlala, at every turn and in response to every question, invokement or affidavit to make available both those documents for consideration by this commission, to which the contents thereof are relevant to the matters before the commission. Thank you, Chair.
Ms. Silo, I'm loath to make such a ruling without full argument on the point. I'm not sitting here. I'm not altogether sure how Section 105A10 should be interpreted. For purposes of whether this commission, regardless of nullity, have access to and use the affidavit produced in the context of the plea bargain proceedings. Sitting here now, I'm loath to right away make that kind of ruling. I would have to be addressed fully and with written submissions on the point. Making a slightly different point when I engaged Ms. Missy right at the end before the adjournment. I was saying we go to the point that raised the question of whether this commission should have access that 204 statement. We got to that because Mr. Matlala chose blanketly to rely on that statement to assert the privilege. And the point I was making was the proper approach for
last minute mom, or aesthetic mom, whichever mom you are, pour little fun into every day with Stereo Stampy.
Specific crime, Raf says so, and say because of that specific crime, this is how that question impinges my privilege. For that purpose, he ought not to rely on the fact that he has made a 204 statement, because that doesn't specify the crime on the basis of which he is asserting the privilege. So that's why I said we ought not and we should not have reached the stage which we reached. We reached it because of the which Mr. Matlala kept referring to the 204 statement. We should not get there. I would suggest that we adjourn. Your questions again. Mr. Matlala, I repeat, and this was the purpose of the adjournment. I repeat that I blanket reference your 204 statement because the 204 statement is not in and of itself a side of specific, I think, a specific crime for purposes of the judgment that I have referred to, and which is authority, how and under what circumstances you can assert the privilege. So do not again blanketly refer us to statement. Tell a crime and then claim your privilege. So for now, let's just proceed questions on the basis that I will hear nothing of this blanket reliance on the Section 204 statement. And if you insist to have sight of that statement or affidavit, I will insist on being furnished with written submissions by both sides on the issue, Mr. Silo.
I accept that, Chair, if I may, with your leave extended, much as you say, Mr. Matlala, in refusing to answer a specific question, must specify the offense, which is what section, paragraph 109 of the Zuma judgment tells us. Equally so, and the purpose for which we played that clip is that very document is null and void in the very criminal trial that he is currently facing. So he can't invoke it for purposes of for fear that it will prejudice him in those proceedings, so he can raise that as well.
Yeah. Hear you.
Thank you, Chair.
I think that's a valid point. Yeah,
Thank you.
I hear you. Thank you.
So then, Mr. Matlala.
I hope because when we took the break, Ms. Missy, that was the point on which I was engaging you. That is, I will have none of this thing of this reliance on the Section 204 statement. That's when you and your junior engaged each other, and when I said, let's rather take an adjournment rather than watch you engaging with each other. So I hope you did engage Matlala on the point, which is the point I raised with you specifically, and that Mr. Matlala now understands that he can not in a blanket fashion just say, because this was in my statement. In any event, Mrs. Silo makes a valid point, which is that the fact that it is in that statement can't be used in proceedings anyway. I'm just expressing a hope that this was discussed fully. I hope I'm not inviting a debate.
No, Chairperson, you're not inviting a debate. I can confirm that we did impress on him and explain to him why you're taking issue with it with regards to the statement. And so I do hope that moving forward he'll be able to answer you as per that issue.
Thank you. And Mr. Matlala, the making applies across the board actually. It's not just about the Section 204 statement. It applies to any and every issue that may arise upon, or rather, based on the questions you are going to face from Ms. Sidlo. So you cannot, in very broad and generalized terms, say that's going to incriminate you. We should know what the crime is, and then based on that and looking at the question, see whether in your asserting the privilege is warranted under those circumstances.
Thank you,
yes,
Chair.
Yes, Ms. Silva.
I take it, Mr. Matlala. Did you want to say something, Mr. Matlala? You looked at the chair like...
Yes, if you want to respond, you may.
Acknowledge what you were saying. There's nothing more.
Okay. Then how we got here, Mr. Matlala, was we were engaged on your third, fourth, whatever, incident where you met with General Sibia and you said that he had invited you to discuss the kidnapping of Mr. Bushoha. You then said that you cannot go any further detail as to that engagement, and for that purpose you relied on Section 204 statement. So you cannot in the manner that you choose to, because in any event that statement itself has become null and void. So that I repose my question. Please state to the commissioners the nature of the engagement you had with Advocate Sibia, General Sibia, about the kidnapping of Mr. Bushoha. My apologies, General Sibia.
I think on that issue, I already said that he asked me what do I know about it, or you want me to explain, after he asked me what do I know about this kidnapping, do you want me to explain what did I say to him?
Yes.
Okay. Yes, he started by asking me why are they accusing me actually of that crime? And I took him back and to him that as soon as Jerry's was kidnapped, I suspected two things. The first one was he went to Jerry's house together with Jerry's brother, and then Jerry's brother said to me, I must ask to give me Jerry's cell phone, because should she find out that there is Jerry's side chick's number, it will go crazy. And then she said I must lie to her and say this phone is going for investigation. And I did that. That's the first point. So the second one is Jerry's wife and Jerry's brother. Why don't we tell the police exactly what was Jerry doing, so that at least when they looking for the, and then I think those two things might have triggered what Jerry. I kept Jerry at my house, which is not true anyway. So, but those are the things that I discussed with General Sibia.
And are you able to say what was the outcome of that engagement? Because it's not clear whether he was talking to you or with you in his capacity as an investigator or purely as a police officer where others are investigating that kidnapping.
What he said to me, he said that if he can crack that case, it will help him a lot. So I will assume that, obviously, because he wanted to be the one maybe to crack that case. Then he wanted to know what do I know about it, since Jerry was my friend.
And I think Ellie asked whether after that engagement you had any further interaction with him about this matter.
Kidnapping matter?
Yes.
No, he never, it was only that time.
Okay. Yeah. Now, recall that we were dealing with these issues because paragraph 2.2.3 had inquired of you the nature, extent, and frequency of communications and physical meetings with. We had said this perhaps is about your third encounter with him. When next did you meet with him, and for what purpose?
The other encounter, I said, is the one to talk about it because I'm charged with corruption. I'm not talking about 204. I'm being charged with corruption, and then they're investigating him on that matter. So,
please say the last bit again, and also
the investigators asking him. Firstly, I'm describing the crime. So yes. I said I'm being charged with corruption.
The Pretoria case.
The Medicaid, yes.
The Medicaid case.
Yes.
Oh, this is corruption in the ongoing criminal case, or would that be an extra charge?
Ongoing criminal case.
You then, this corruption that you fear you may face a charge for arises from your physical meetings and gatherings and communication with General Sibia. And would both of you be charged with corruption, or just you?
I'm already charged, so I'm saying I do not want that making my trial difficult for me. Well, basically what I'm saying is it will infringe my fair trial.
Okay. So that will infringe your rights in the ongoing corruption charge in what we call one of the offenses you are charged with.
Is this the IDEC investigation?
Correct.
This would relate to your interaction with General Sibia. You disclose something, you say, that would compromise your defense against the fourth interaction with General Sibia.
That's correct.
Okay. And
there's two occasions, but both is the same corruption charge, yes. I'm not mentioning I went to see him in this office for the issue and also for the public works.
So, if I understand you correctly, After your engagement with General Sibia 3 more times.
Commissioner, I'm just saying on top, I cannot just saying from the top of my head, I'm not sure about that.
Oh, and where's it? My 3, you had said, I said, when was the next time you met, and then you brought up there. And I say, beyond that interaction, any other, you say 2 other occasions. That's how I land on my 3.
I said, except 2 other occasions when we met in his office. 3 occasions.
So now you had this interaction potentially undermine your defense in the ongoing corruption case. I want us to get past that interaction. I want the next time you met with.
There is no next time.
Was that the last interaction you had with him?
Yeah. The last interaction is I think is what is it? Engagement party. I don't think there was a call.
So the next time you met with him thereafter, to your recollection, what? You have to verbalize your answer.
Yes, I said that.
Don't nod, Mr. Matlala.
I'm sorry.
Thank you.
The recording doesn't see a nod. And since the engagement party and the interaction at the engagement party, have you had any meetings, physical or otherwise, communications with General Sibia?
No, I've never.
When was this engagement party, to your recollection?
Sometime in 2024.
So you said, okay, you can use the season, winter, summer, I'm trying to...
I think
Courtney and Mac love playing tug of war with his favorite sock. Mac wins, swallows his prize.
Mid-year 2024.
July, maybe July, somewhere there.
The other witnesses not say it was 14 September.
I'm not sure, Commissioner. I'm not saying that. I'm just.
There's confirmation that yes, that the witnesses so said.
He might.
So then I'll accept that. The last engagement you had with, or interaction you had with the engagement party in 24, what the actual date was?
Not the last. The timelines, I'm a bit confused with them. It's one of the interactions, yes.
Okay, then let's get past the engagement party. When did you next engage and interact? After, now we have engagement party in our minds. I trust fire was heard by all. So after that, when did you next engage?
What I can remember is our own.
Sorry to do this.
Yes,
there's confusion about the 3rd and 4th occasion. The engagement party was in September.
Yes.
And the raid was on the 6th of December. Then it must mean the engagement party is the 3rd occasion, 4th occasion. Because December comes after September.
Indeed. Do you understand?
No, I understand, yes.
Yes. Remember we discussed the kidnapping of Mr. Bushoka?
Yes, yeah.
And you said it was after the raid.
Yes.
So the commissioners point out to us that the things is not right. The engagement must have come before your engagement with him regarding Mr. Bushoka. Because that was only the 6th of December.
Of course, yes, I agree.
So we should swap the dates around.
Of course, yes.
You said yes.
Yes,
oh, you're still thinking. I don't know.
I'm thinking.
I don't want to rush you.
I'm trying to remember. I think, if I'm not wrong, I also met him in 2025. So I'm trying to remember while you're speaking. I'm sorry. So I was trying to the exact date.
Then perhaps if we say, while we correct that you then met him next in 2025, perhaps if we discuss the circumstances of that meeting and what was discussed, that would help us sort out the order of things, hopefully. So what did you, in 2025 when you met, what was it about and where and how did it come about?
Commissioner, I'm saying I think I made 25. I'm not certain, but judging by the timeline, because after the raid, I remember I didn't have, there was no way after the raid, 15 days, there was no way that I could have seen him because I was busy with police and then I was busy with my meeting with, so it must be maybe January.
Oh, I think I get you now.
I'm trying to have a proper recollection, so.
And is that in relation to around the kidnapping of Mr. Bushokha? That's the one you're putting it around January 2025. Am I understanding you correctly?
Yes.
Okay. So then after the Mr. Bushokha discussion with him, when would then you would have met again?
I don't think I've met him again after.
Since?
Yes.
Have you ever communicated with him directly or Sergeant Ngosi?
Communication, yeah, I think it was Sergeant Ngosi, yes.
Are you able to just highlight communications was about and who had initiated such communication? And if they are different, then you can enumerate each and talk about who had initiated each communication was about.
The communication was through, all the time, was through Sergeant Ngosi.
But at whose instance?
If I remember well, the communication was regarding after the raid, why did I tell the police that I know him? So, I think it should be in December. After the raid, maybe before January, I think there was a communication.
Okay.
I'm just confused. I'm not.
Okay.
I'm sorry. I'm not.
Are you now referring? Remember, there were 2 raids in December. There was a raid at your house.
Yes.
Where the police were looking for Mr. Busho. Then there was a raid at CAT VIP services where there was the issue with the key and the fact that it's not in the right safe and firearms were taken. Which raid are you referring to?
After the first raid, I think 10 days after the first raid, that's when, 10 days after the first raid, that's when I made that High Court agent application. And in that High Court application, that's when I mentioned that I know General Sibia. So that's when I get a message from Sergeant Ngosi mentioned that I know him, because it was in the media, I think. So that's why I'm saying I think in December there was some communication.
So after the 20th of December?
Yes, somewhere there, yes.
Thank you. Do you recall having a discussion with General Sibia about an application that was necessary to launch for the return of the guns and I think jewelry you said had been seized during the raid of your house or office, one of them?
Yes, but that is part of the case that I'm attending in the Johannesburg High Court.
Medicare?
No, not Medicare, the other one. In Johannesburg High Court.
The one concerning the conspiracy to commit murder, attempted murder,
Yes.
and lawful possession of a firearm and ammunition, money laundering.
Yes.
What relevance does General Sibia have?
There is a relevance because I have my defense. I need to establish how did I end up being arrested. So because in my phone records, they are relying that I'm part of me and General Sibia and Minister Mkhunu. We part of people who plan to dismantle this PKTT unit. So that is something that I'm going to argue in trial, that how did I end up getting arrested?
What is the crime in dismantling the PKTT?
The crime?
Well, you said, perhaps I misheard you, my apologies. You said there is an accusation that yourself, General Sibia, and Minister Mtunu are what about the PKTT?
Commissioner, when my cell phone downloads, there was communication which I do not want to, because it's part of evidence in my criminal court in the Johannesburg matter. But there is those engagements and where also General CB has been involved there.
You said something about the PKTT. Can you say that again?
The dismantle, yeah, yes.
So I say, what is the crime in disbanding the PKTT? What's your understanding arising from that case?
Not the crime, not the crime, Commissioner. I'm saying part of my defense. I'm going to establish in court how did I end up getting arrested. The only way for me to explain this to you now, I have to go deep, and which I don't want to do that, and now disclose my defense strategy.
No.
I want to do that.
I'm not inviting you to. I was talking about an application you initiated or instituted in December.
Yes.
For the return of your guns and jewelry, which had been seized during one of the raids. And I asked the question whether you had not engaged with General Sibia around that application for the return of your property. So your response then speaks to the criminal case of attempted murder and the disbanding. And I'm not sure I understand.
Because your question, what you're asking me now, is also part of evidence. What's asked me now is part of evidence, which is in my cell phone download.
Isn't maybe isn't that perhaps, Mr. Matlala, the best way to proceed is the direct question that is asked is you had such an application before court where you went to court to seek a return of your firearms. That's what Ms. Silo has asked at this point. So, it seems to me that your answer would be yes, I did, or no, I did not. And then we pass that, and let's hear what is the next question before you get to a point where you say, but that case has to do with the matter that I'm presently facing and the defense. So maybe take it step by step. At this point, all she asks is you had such an application where you went to court, you wanted a return of your guns and jewelry. And answering that question at this point does not require you to get into the detail of that application, and I don't know if she intends to ask you that further question, but at least as a starting point, your answer doesn't require you to speak about what was in that application.
Commissioner, I already conceded that yes, I've made that High Court application, but her next question was, did I ever discuss that with General Sibia? That was her question.
And your answer could be no. And if she says, what did you discuss? It seems to me that at that point, may well attempt to raise your defense, your privilege.
Commissioner, I don't think it's fair because now I'm disclosing part of my defense strategy now. I don't think that is fair. I don't think so.
You are not, at least as I understand, you are not saying, I don't want to answer that question because it will incriminate me. You are saying, I don't want to answer the question because I don't want to disclose my defense strategy.
That's correct.
So it's the second.
Yes, that's correct.
And Mr. Law will decide whether that's good enough for purposes of further discussion.
Well, and perhaps it's a tad unfair to Mr. Matlala in Section D sub 4 of the Act, which means he must invoke some legal privilege, and in 610 tells you that the only basis to refuse to answer a question is if you establish contemplated in Section 4, which is a privilege as recognized in law, and fear to lose your defense as not one such privilege. So if that is the only basis, then you do not bring yourself within that of protection, because that does not constitute privilege, and you will be compensa. You are raising a wrong basis to refuse to answer. It's not an acceptable basis, as determined by the law, not by us around here.
Maybe, Commissioner, is because you are speaking just a mere layman. I do not understand law, and then I do not know which case law I should invoke in these things. I think maybe my legal counsel will help me with that. I do not know how to invoke which section for that.
I think that's fair. That's fair. So maybe to address myself to the commissioners and ask the commissioners to inquire from Advocate Misi whether she would like to engage with that point on your behalf.
Thank you.
Thank you.
Ms. Missy,
Should I answer?
what are your
May I answer
submissions,
rather?
your submissions in response?
Yes, Chairperson.
Does the privilege extend to not, a witness? I will not answer because I do not want to divulge or reveal my...
At some point, you raised the question as to what exactly is this charge that you are facing that speaks to that particular piece of evidence and defense that you would not like to disclose before the commission. One, because we were only briefed with regards to the proceedings before the commission, we're not fully aware as to what are the charges that he faces in that matter that speak particularly to that piece of evidence. Say to Mr. Matlala, we do understand you from this perspective here, you would be able to claim your right to the privilege in terms of Section 3.4. And so, Chairperson, the only thing I could do at this moment is if the Commission could allow us a stand up so that we can consult with regards to this issue, bearing in mind, like footing on with regard to the charges that relate to the case before the Johannesburg High Court, I believe.
Just repeat the underlying facts that give rise to this issue, so that when instructions are taken, they are taken in the context of the point from which you moved to,
yes,
for us to get to where we are now.
The chair will recall that Mr. Matlala and I were recounting the incidents he met with General Sibia and they discussed, and the idea was to understand the content of such discussions on each incident. And I had posed a question to him whether he had met with General Sibia regarding an application he instituted for the return of his firearms and jewelry, which he stated at the time had been seized during one of the seizure, one of the raid incidents, either at the home or subsequently at his office. And he confirms, yes, he did institute those proceedings. The question was whether or not he met with General Sibia and discussed that with him, to which then he claimed he invokes a privilege, not in the Medicare matter that we've been dealing with, but the other matter in Pretoria, I think, about conspiracy, attempted murder, unlawful possession of a firearm and ammunition, as well as money laundering. So it is in the context of understanding the charges that he's facing there, I'm trying to appreciate what his engagements with General Sibia regarding, I would term it, the lawful return of his property, what bearing it would have on that case. And that's where I think we fail to find one, or I fail to understand. Let me lay it on my doorstep.
Thank you, thank you. Yeah, maybe for a fuller background, during the raids, some of Mr. Matlala's companies, properties, and indeed even his personal items were allegedly, with regard to the personal, and I think it's common cause with regard to the property belonging to the, were taken by the police during the raid. And the alleged relates to, I think, Mr. Matlala, in a court application in which he was seeking a mandamus, in terms of which he said his, amongst others, his Rolex watch, or was it a Cartier? Oh yeah, Cartier and Rolex watches, and maybe some other personal item had been taken by the police. So in terms of the mandamus, he wanted the court to direct that those items be returned. But if my memory, I think in the end, he either withdrew or did not pursue those applications any further. So that's the full context. And so Ms. Sillo is engaging Mr. Matlala on that. Sitting here, I have no idea how that has anything to do with Mr. Matlala's defense strategy. But in any event, there's the point that Ms. Sillo makes, which is, what's Mr. Matlala's defense strategy got to do with the privilege he is claiming, which is the privilege against self-incrimination? So that's the full context. Would you still say you want to take instructions, or would you accept that there is no basis for asserting the privilege in this context? Or perhaps it's not even the privilege, it's something, some other animal, an animal that I will not answer the question because it discloses my defense strategy. But in any event, I just do not see how an application for the return of Mr. Matlala's personal items, I do not see how that relates to any possible defense to whatever charge he is facing in this regard. But in any event, there's the antecedent question. Can he refuse to answer the question on that basis in any event?
Chairperson, while Mr. Matlala was giving his submissions, there was a point at which it seems to me that he makes reference to the issue of a charge and or within the case that he's referring to. And I'm wondering to myself, without having full knowledge, is there a misunderstanding on his part that we would need to consult with him about so that we're able to correct him and give whether he's approaching it incorrectly? This is the manner in would have to make the application or claim the right to privilege. Because I do specifically recall him making reference to a charge that relates to the matter. And that's why I'm saying I don't know what the charges are. I don't know how it relates to this particular piece of evidence that, or rather the issue with regards to the application not proceeding, how those two interlink, because now suddenly, or rather later on, he makes reference to it being part of his defense strategy. And as he knows person, he perhaps might not be viewing this correctly, but he actually knows what he's trying to say.
Is that a point he can raise as a matter of law anyway? That is, I will not answer that question because it discloses, or rather my response with my defense strategy. Is that a legal basis for refusing to answer a question?
Chairperson, now that we've taken the instruction and we decided to proceed based on where we are, having not heard the application or procedure point, I believe during our consultations and as part of the application, it called into question as to whether as a suspect or as an accused, does he have a right in terms of Section 35, and it would go towards the issue of a fair trial, which there's a confusion with regards to that. I'm just off the top of my head on his part, and that's really important before we proceed, for him to answer it. Can we get an opportunity to understand exactly what is this point that he's raising that has to do with the charge and the evidence, as well as the defense that he wants to raise, Chairperson. I do believe, as he noted, that he's a lay person and lacks a proper understanding how. It's also to avoid an instance where, again, it's just regarded as a blanket approach of, because I am going to use this as a defense in my trial, therefore I don't want to address it. I do believe it's important that we get the opportunity to get an understanding exactly from why is he referring to this, why did he mention the issue of a charge, how does this all interlink, and then we can give him proper advice that in terms of claiming privilege, you have to make reference to the specific charge, etc., before you...
I have bent over backwards and allowed you an adjournment each time you ask for one, but we will never finish Mr. Matlala's testimony if at every turn we have to do this. We have to adjourn for you to take instructions, and I thought this is just a legal question, and sitting here I just do not see the connection whatsoever with regard to an application, a civil application for the return of Mr. Matlala's goods, an application which he did not pursue. He either withdrew it or did not pursue it to finality, so it died a natural death. I just do not see, sitting here, unless we get clarity, I just do not see how that has anything to do with his defense. But as I said, the antecedent question is, can that even be raised as a basis for not answering the question?
My question to that would be no, given where we are proceedings. However, I still stand by the fact that he very well, just on that particular point that he tried to explain on with regards to the charges, he very well would be able to explain to us at least so that we can give him properly whether he can claim a right based on that or not. Because Chairperson, like he said, he's a lay person. He's probably trying to approach it from this angle, but in reality, this is exactly what he's meant to be claiming based on ABCD. I don't know what the facts are, as much as I also don't know what the charge is that he was trying to make reference to. I think I'm grappling with the fact that he did try and address the issue that has to do with charges, and it relates to the defense that he wants to raise. I also don't understand to what extent it would affect his ability to raise the privilege to not self-incriminate. However, I do agree with you that he can't raise the issue of fair trial, i.e. with regards to disclosing his defense, Chairperson. And that's the reason why I've asked for a stand down, so that we can at least give him that legal advice so that he understands where we are right now.
Yeah, you see, the difficulty with that approach is that it would be a matter of relative ease for every and any witness to say, I will not answer that question because it discloses my defense strategy. In instances where we look at the facts, it does not immediately spring out, or the circumstances do not spring out and tell you in and of themselves that this has something to do with a possible defense. Civil case, civil application, withdrawn, and apparently, at least from the evidence that we have had, on the basis that no Cartier or Rolex watches had actually been taken from Mr. Matlala, how that should then lead to the disclosure of his defense in the criminal case, for the life of me, that escapes me altogether. So the short point I'm making is it would be a matter of relative ease for anybody to say, I will not talk about that. That discloses my defense. And if there is no cogent explanation, we cannot accept that. We simply cannot accept that.
Sorry, Chairperson. I think maybe I can assist if you allow me.
Yes, please.
Because I have to agree with you. You are right with one thing when you say you don't understand civil matter has to do with my criminal matter. Even myself, I didn't see the necessity of why the state will bring that up. But as you're saying, anybody can come up here and say this will infringe my fair trial. I think what is best that I can do to prove that this thing is part of my trial and then is part of the case that the prosecutor has been relying on. Maybe if I can bring maybe a copy that is signed by the investigating officer to show that indeed this is part of my case. Tomorrow morning, I have that document on me. I can bring it tomorrow morning.
I see that it's 2 minutes to 6. Perhaps we should adjourn at this stage, and then that should afford sufficient time, Ms. Missy. And yeah.
Person, before we do adjourn.
Can you please
My
pull the mic or
apologies.
speak?
Yes, I would like to understand the position with regards to the suggestion that has been made by Mr. Matlala, which is that perhaps he ought to provide us with a copy, because as I stated, I haven't seen it as well. I don't know what these charges are, and so it's so difficult for me to answer you and address you with regards to us have a good point to make there. So what is the position that...
No. That's acceptable. That's acceptable. Yes, you may bring Mr. Matlala.
Thank you, Chairperson.
Yes.
And Chair, before we perhaps then to facilitate our engagement, it might assist if we were provided with both the charges and the attempted murder case. I'm not asking your documents, I'm asking just for the charge sheet, because that would give us a sense of what the offenses Mr. Matlala is charged with.
I think I have my charge sheets. The charge sheets, I don't know, I will ask. It's fine, we'll make,
Chairperson, because if I may, I believe Mr. Maluleke is the attorney on record in those matters.
Of course, yes. Yeah.
And he's still on record here. Surely that would be relatively easy for us to provide same.
Thank you.
Thank you.
Thank you. Let's at 9:30 tomorrow.